Okay. And we are now at 6 o'clock, so I'm going to let them in.
Sure.
Okay, good evening, everyone, and welcome to our final seminar for 2021. Tonight, we are lucky enough to be joined by Mohammed Haque with the last in his Adjudication Matters series for this year, where he'll be talking about claiming time and money in adjudication, the penultimate, also the last one in this series. As always, he's happy to take any questions from you. You can use the chat or Q&A facility in the bottom toolbar. Alternatively, if there's something you'd like to ask, but you don't wish to do so in an open forum, absolutely no problem. You can see his details on screen there, mohammed.haque@fletcherday.co.uk, and he will happily answer these questions on email for you. Okay, without any further ado, Mohammed, it's passed over to you. Thank you very much.
You're welcome, Julie, and welcome everyone who's joining us this evening for my last a part of the webinar I've been running since the beginning of the year. There was someone who sent me an email after I have done the last webinar, and I realized that there are people within the audience who's not aware that I have done some of the episodes of this webinar as part of Silver Shemmings earlier. So if you are willing to or need to look at the beginning parts, you have to go to the Silver Law YouTube channel because I don't think the website's still live. And if you want, you can ask Julie, of course, to send you the links. Having said that, this is the final part. And I think if there is anyone who's been there from the first part in this series, for them to keenly and attentively listening and also asking me various questions over a period of time. Some of you have called me from different parts of the world, finding it very useful. And some of you have asked for various documents I've referred to within earlier webinars. So all in all, it seems that it worked for those of you who have attended and watched and tried to understand adjudication. To be updated and keep yourself up to date, you can always visit the decisions page of the TCC, which is absolutely free. It will take you to the Bali TCC cases, and you will find month-wise updates. So all the case laws are there. And there are wonderful blogs over the internet. Leading law firms and chambers give a lot of materials, post a lot of materials for adjudication. So keep yourself up to date if you're not through these modes, if you're interested. And by all means, if you are interested, you can also join me or my network on LinkedIn, because I occasionally give posts there as well if there is a good enough case which needs an update. And I'm planning actually to convert these webinars into written articles and publish them over the LinkedIn. So if you're interested, you can join my LinkedIn network to be updated. So having said that, we come to today's business. And as I said, this is the last part. I'll be discussing briefly today what different types of money and time claims are made under a construction contract. Because it's one thing to try to discuss what did Lord Denning said or Diplock said, how that was different from what Lord Justice Colson's saying today, that sort of thing, which is good, which is needed, but for a practical day-to-day approach, you need something real and practical, and that's what all I try to do throughout the year, not to be like a law tutor, but to be a professional senior, to let you know how I work, how it's organized. So essentially, under adjudication, we have two types of claims. Primarily, one is, as we call them, smash and grab. That is due to payment technicalities in the in England and Welsh. We have statutorily granted a right to adjudicate, and no crystallization is needed. If somebody failed to issue the notices, then a notified sum is crystallized, and the payer is under an obligation to pay this. Now, if anybody in whose favor a notified sum is accrued, he can go and adjudicate. We popularly call it smash and grab. I've discussed it last week. This week, I will discuss the claims, the normal claims we find for time and money under any construction contract. Of course, the main focus is going to be JCT and NEC. They're the two types most popular. Of course, I've worked on IKME and ICE as well, but these are the most common ones. And I've just taken like a stock of what sort of claims are normally coming. Okay, because we have got interim and final payments, so we've got payment cycle valuations, and it's not unnatural that party A says, okay, you've performed this much of the work, that much is not in accordance with the contract, so I will not pay you for that. And although this much was planned to be performed, that was not done, so I will not pay you the full money. So for any period or the final payment, this is always possible that there's a dispute over the valuation of the works done because it was misperformed, or there was a defect, or it was not performed at all. So that's sort of thing we call a valuation dispute. And this valuation disputes and relates to, of course, a recovery of money by either side. Whoever wins, he gets back the money, or at least gets paid. So if it's a valuation claim by a contractor and he wins, and if the employer's valuation was less, and that's the only reason why it will be, but then he gets paid. If it is other way around, so any overpaid sum will be recovered by the employer. So that's one type of claim. Then entitlement arising or amends arising out of change instructions and their valuation. So I'm running a separate sort of series of webinars. That's another important aspect of construction contracts that's inevitable. I mean, I've been in the industry for 25 years and I haven't seen a single contract which never had some sort of changes which has had some impact on value. So, and as soon as there is a change, the change needs to be valued. Now, if it's a JCT, we call it a variation valuation. If it's NEC, we do it through compensation event. But whatever the name is, what is in the name, at the end of the day, you got to value it. And it's not very uncommon or infrequent that the parties start differing about the valuation of the variations. And especially I've found like for those contractors who are working, or consultants who are working for the residential buildings for the occupiers and the owners, what happens, the employers and the owners, without realizing the valuation impact of some change, they keep on coming to the side because it's an emotional thing for them. And then they change, you know, they ask, okay, do this, do that, and do that, and all these. And then they do not realize that there is a valuation implication to it. And so frequently later on, a dispute arises, you know, as to the real value of the entitlement of the valuation of the change instructions. So that's another type. Of course, you carry on applying for the variation account or the compensation event valuation account simultaneously with your measured work entitlement. But that's that, okay? then obviously you like it or not, if there is a provisional sum, and those of you are new, if there is any, a provisional sum is a sum which could be one of the two ways. The definition, if you want to, is the only definition that should be relied on is the one contained in the NRM, New Rule of Measurement. So a provisional sum is a sum which either couldn't be defined because maybe the specs or the drawings or something else is not finalized up to the point of the contract. So just a outline sum has been agreed, and as and when the things are available, it's the provisional sum is then decided to be expended, and that's obviously a change, and you need evaluation. And the basic rule is, again, as per NRM, that you deduct whatever amount you have added at the time of entering into the contract, and you do either by an agreed basis or through some other method, a fair market value, whatever rules apply, you find out the value of the provisional sums. And there are contracts where, due to the peculiar nature of the industry, you may have a huge sum, which was actually a provisional sum, and for which valuation disputes are quite common. The other type of provisional sum is the defined provisional sum, where there wasn't any problem in deciding the price or the spec, or nothing was left out. However, the employer was not too sure if they want that thing or not into the project. These are called defined provisional sums. And the only difference between defined provisional sums and undefined provisional sum is that in a defined provisional sum, you don't need to identify you don't need to enter into evaluation again at all. However, for a defined provisional sum, you cannot ask for extra prelims, okay? Because it's assumed under NRM that you have provided for prelims. Whereas if it's undefined, then you have the entitlement to add prelims to your valuation of the provisional sum. And mind you, one thing, if you are, again, don't take it otherwise, if you're new to the industry, just let me remind you that NEC, the new engineering contract suit, doesn't have any provisional sum. They don't want to live in uncertainty. That's why NEC is sometimes called never-ending contracts. So every time something new comes in through a compensation event, you agree to add that to the contract, and the valuation to everything is and what extra time you need is always added to the contract through that mechanism of the compensation event, or CE. Now, interestingly, that makes sometimes it more common to have dispute and claims about it. Claims of loss and expense. Claims of loss and expense is actually a claim for the contractor equivalent to the claims of damages by the employer for delay. What I mean is, if there is a delay and the employer is responsible for the delay, or the delay is the employer's risk event, in that case, if the proper notices and everything has been given, then the contractor gets an entitlement to claim all its losses and expenses due to the delay. The most common and obvious one comes in is, of course, the prelims. You know, every expenses that you have to, and any other extra or additional expenses or costs you have incurred. And I will discuss it into the example I'm going to see or go through with you today, a loss and expense claim. Now, then comes the claim of liquidated damages. The liquidated damage claim is, or better said as liquidated and ascertained damage, is a rate of, or a lump sum amount of money, which is applicable for each day or week or a month of delay. Sometimes, so what it is, this is a formula through which the parties agree a sum that in case there is a delay, the employer is going to receive this much. Okay. Now, this has to be genuine. Of course, it's not a penalty. It has to be a genuine, ascertained delay related damage. It shouldn't be fantastic. Sometimes it's capped. And one of the downsides of having a liquidated damages clause is that the employer cannot treat the date of performance as the essence of the contract, because historically in English law, if damage is adequate, then you lose the right to call something as an essence of the contract. Having said that, there is no legal bar to agree that expressly within any contract that regardless of the fact that the contract provides for ascertained and liquidated damages for any delay, the employer will nevertheless have the right to terminate without showing any cause whatsoever if a particular section or a particular performance as fallen due is not done on the day. Now, again, just because we are discussing, if it's a JCT contract, the program is in the hand of the contractor. So it's not in that sense a contractual program that has to be complied with. So the only date that's relevant is the date of practical completion on site. So if only the contractor believes that that's going to hinder, that's going to be delayed, anything comes in place. Okay. However, if it's a contract where the periodic programs become a common thing to produce and it becomes part of the contract, then if you haven't said that time is sense regardless of the liquidated damage, the tendency of the courts is to hold that if you have a liquidated and a certain damage clause within your contract, you cannot call the time of performance at essence unless otherwise described. Unliquidated claim and claim of damages is something that arising out of breaches, or if there is a defect which has shown itself after the defect liability period, or if within the defect liability period there was a defect and the contractor was asked to rectify it, and the contractor didn't attend site or remedy or rectify the defect, then of course the employer cannot just sit tight. They have to do it somehow, and that somehow is the employing someone else. So for that, where they incur cost, and they can then recover it from the contractor if they have given them the due notice earlier that you have no other choice but to do it because you're not attending the site. Of course, in almost every construction contract, there is a clear-cut provision that if payments are delayed, the aggrieved party is entitled to interest. And now, due to late payment of Commercial Debts Act 1998, we have a statutory implied term right under that statute. So that's another type of claim. It may not arise like a claim on its own, but it could be a claim of a part of a wider claim. And inevitably, almost in all construction contracts, we have deduction of retention by the employer because in case there is a defect and the contractor doesn't attend to rectify the defect, then the employer can do something by using that money. He can rectify the defect himself. So that's the reason why retentions are taken, and generally, again, as a norm, we refund 50% upon practical completion, and then the rest upon, provided there isn't any defect anymore, or at the time of the final payment. So after the defect liability period, the final 14 days or 2 weeks or 3 months, whatever it is, the employer gets the final chance to call for the contractor to come and attend the site. So if there is a dispute about the retention amount and how much should have been paid back or how much has been refunded or not refunded, that's another thing. So these are more or less. So the reason for me to let you have this is right from the day one, please sort of have a track sheet of some sort where you specify and keep on tracking if any sum is overpaid or unpaid due to a valuation dispute. If there is any entitlement arising under any change instruction, what are the different types of changes? Of course, as I said, I'm doing another separate webinar series on changes. And then as soon as a provisional sums instruction to expend is given, look at it, was it defined, was it undefined, and try to close the valuation, or if not possible, then remember that this is another claim. And then of course, loss and expenses, I said, I will take a full example on this. I'm not going to give much of it. If there is a delay, save your skin by putting the notices correctly and trying to achieve an extension of time decision. If that doesn't come, then the contract is at large, but that doesn't mean I will, in the next slide, explain it something more. And then of course, if there is any breach, then unliquidated damages, that's a common law position. And interest, if there isn't any form of interest being allowed for late payment within the Act, it's available under, within the contract, it's available under implied terms by Late Payment of Commercial Debts Act. And of course, finally, the refund of retention is another issue, because you will get it quite late. So sometimes it's easy to forget it, but do not forget that as well. Then the popular claims of time, obviously revising and fixing the date of practical completion is the vital thing. And the whole saga or the concept is that a duration between, and which is vital, a duration between the commencement on site and the ending on site with practical completion. Okay, these are the two milestones. These are the two day zero and day. It's not the day of signing or pre-site preparation that's that much important. It's between the day you move onto the site and the day you complete it. This period is the period which is under consideration. And normally the contracts specify one date only for the practical completion. And that practical completion date is, if you think cannot be achieved, is needed to be revised, is vitally important. And it is slightly a different thing than an extension of time, because even if an extension of time is given, the contract on its major pages, it states that the contract should come to an end for parallel completion should be achieved on a given date. If that date is not changed by the project manager or the architect or the contract administrator, that means it has not been changed. And that means for any day you are on site beyond that day, you are actually responsible for delay related claim, which is liquidated damages. So, and it's not unlike, not surprisingly, a number of claims hinges around that. You know, the practical completion. At the moment, I'm sitting on an adjudication on practical completion. Now, extension of time claim is a claim which is kind of a recurring claim, because if you're a contractor, do not forget that every time you see that there is a delay, you got to issue a notice. And if it's an NEC contract, you got to actually issue an early warning notice, EWN, and then it's settled through a compensation event. If this is a JCT contract, you got to send them a delay notice, and then your estimate of how much time do you need extra to perform it. And there's no time today to discuss the whole of kind of the floats and the logical chain and the critical path and crushing, and how can you reshuffle the works to sort of still achieve the practical completion. But that's something you got to constantly keep on track. Not only it's a failure of issuing a delay notice in JCT, for example, it's a failure which may lead on to a decision that you are not proceeding duly and diligently. It's another fault. So on the contrary, if you are on your shoes, if you make your claims properly and timely, pursue it, then if the architect fails to decide, or the contract administrator fails to decide within a time, as soon as possible, he gets all the particulars, then the contract gets at large. But don't get so excited, the contract's time is at large, meaning that delay damage cannot be, liquidated damage cannot be imposed. No, it's not like that. You will then be entitled to a reasonable period of time to complete, and up till that point, the reasonable additional time, no, there will be no delay damages. So why there will be a delay, which is the employer's risk? Because delay in handing over. Similarly, why there will be a delay, which is contractor's risk, fail to mobilize on time. So just of these, some of the examples I've given here, but one of the delays sometimes maybe contractors get so excited when they receive a change instruction, which is apparently giving them some money, that they completely forget that there is a time implication of that change instruction as well. So please, if you are claiming on that, or if you are even involved at an earlier stage, please keep in your mind this aspect. Now, of course, there are hybrid claims. I name it hybrid. It's not like anyone else calls them hybrid claims. I call it hybrid because these are money claims, but relating to time, where the issue is not extending or revising and fixing the practical completion date. It is that, well, I want to cite, I was held back for 3 hours, and for that I have lost this much amount of money, or incurred, let's say I had to work in the evening and I had to put a generator on for the lights because there wasn't any light available. I was working outside and all this. So that's a disruption claim, and it's a money claim, but it's time related. All right. What's the basis? Where do I get the reason for my claim? The majority of claims are nowadays, especially if it's a model form, are actually arising out of the express terms of the contract, meaning that the articles, for example, the JCT, the articles, the agreement, the recitals, the particulars, the conditions, and then the extra clauses we have, and the schedules and whatnot. And similarly, if it's an NEC, the core clauses, the optional clauses, and then the works information, and so on and so forth. So all these are written in this book. So it's important if you are claiming to set the context, okay, because the context will give us the text, and the text will let us know our rights. And on many occasions, the contract specifies what will happen, what's going to be the consequence of a particular event happening, and how much can be claimed, what procedure needs to be followed for such a claim. So rather than thinking about common law and all these, first try to find out what the contract requires. Good news is, even if the contract express terms not giving you something, or you fail to follow a procedure as laid down in the contract, for example, if there is a request from, let's assume that it's a JCT contract, a request from an employer to do something, and the contractor has done it, but the architect or the contract administrator, whoever is responsible, never issued a formal change instruction. What will happen? It's not a variation. unless the contractor issued a variation instruction, because that's an opportunity. If that's not been done, in that case, how can you justify this? Under the express terms, no valuation is available. However, under common law, you stand a chance, because if it's been requested whilst you are performing the contract, and you have done it, and then you have taken the advantage of the works, then you are entitled to get a valuation under, of course, a common law implied term that it's not only necessary, it's not only reasonable, it's necessary to have such a provision within this contract. Otherwise, the contract will lose business efficacy. So, for express terms, if the procedures are followed, if the entitlement is given, if the right is accrued as per the steps given, fine. You just keep on linking one with the other and you get it. If not, then implied terms. And I've already discussed the common law one. Let's talk about the statutes, okay? Various types of statutes, let's say goods and services, Supply of Goods and Services Act 1982 as amended, provides certain implied terms regarding goods that are used for construction purposes. And for example, if it's not of suitable quality, despite the parties have agreed to it, no good. It has to be of suitable quality. And if that fails, the contract work fails. But not necessarily it's going to be a defect. Defect is a defined term of problems of some sort being visible. But it could be a breach of the contract, and whatever loss is suffered by the aggrieved party, that can be recovered. And that's a dispute under the implied terms of any contract, and it's quite common. Very recently, I was working for a claim, and it didn't proceed later on, that one type of steel was agreed by description, that is, as parts of the goods to be supplied. And that was not done by the contractor, okay? So it was specifically agreed that a particular type of steel will be used for the structures of the building. And it was only found after the contractor has left the site that they used a different type of steel. Now, the employer obviously had the choice of suing the contractor for failing or breaching the contract, and whatever loss they're suffering, because it's an implied term by the statute. So it was like they could simply sue them on the breach, and whatever loss they would suffer in replacing them. So that's one example. There are many. Now, due to any breach and claim of unliquidated damages, that is breach of any of the above, but then the breach is not disputed, the quantum is disputed. That's what I'm trying to mean here. So the breach is accepted by the parties. The parties are saying, oh no, this much cannot be claimed. I mean, if you are surprised that why is it so relevant? Let me just give you an example. The last large international construction arbitration I did as a party representative, a part of the team involving QCs or leading barristers with the country, the claim was, we defended it, the claim was for 42 million, and we've successfully defended it to 3.8 million. So it's not unlikely or a novel thing in construction that the breach is accepted, yet the unliquidated damage calculation is in issue, and it could be a claim of simply of quantum, you know, and it could be due to repudiatory breach or breach which entitles damages, or even post-termination. So even if the agreed position is fair enough, we've agreed that the contract is terminated, the real value of the accrued rights is this or that. So these are quantum disputes, and these are quite frequent claims as well. So Finally, for these type of things, we more and more have in adjudication declarations for time and money too, that he was entitled to an extension of time, that sort of thing, up to such and such date. Now, a little bit more I wanted to have on the time claims and delay in handing over, failing to make the site space available, change in site conditions, delay notice is issued, but no EOT decision is issued. The contract went in large. I actually discussed already these issues today. Delay due to change instructions, including instruction to expend provisional sums, hybrid claims, and disruption claims. I've more or less done the explanation. And of course, we then come to how do we adjudicate? No difference. There must be a construction contract. There must be a dispute. The dispute must be under the contract. Only a party to your contract can adjudicate. The notice of intention to adjudicate must be given first if the scheme applies, of course. And nomination application must be made after that. The referral notice. And if you are doing this, please keep in your mind that when you are asking the nominating body, the best time to show that I have already given this notice to the other side at such and such time during today or yesterday, and then sending it. It's best that you do it on the same day, but ensure, and always it's a good idea to ask for an acknowledgement to receipt report, electronical, and also to have a delivery report, so that when you are asking the nominating body, you just send that information to them that I've already done that part of the scheme. So there isn't any confusion later on, because if you do it on the wrong order, then unless the other side agrees, there's no one can save you. Even the adjudicator, even if he wants to, that's silly. No, he can't. It's a nullity. It's in the hand of the, or in the mercy of the responding party. And then, of course, you have to draft a notice and referral for the time or a money claim in any adjudication. That's how you start it. Well, conclusion, of course, I will not conclude at this point, because as I said, I will discuss an example, okay? And I'll come back to the conclusion in few minutes. Okay, so here is this example, which I've drafted for a time-related claim. This is the example for Cha-Cha Construction Services against Jana Ja Services Europe Limited. So one is Cha-Cha, the other is Jana Ja. The contract is about building it's about the construction of an internal fit out to form a new reception, lounge, bar, working areas, toilet facilities, back of house kitchens, and staff welfare rooms at level 20 within the existing market building, London City Plaza. I've redacted it, of course. It's a live thing, but I've redacted it. And it's been a very protracted, in which I've been involved, fight for almost a year, or more than a year actually. And external roof plant grantee at level 40 and level 20 of the London City Plaza Terminal 3, the works. The contract was a JCT. It had provisional sums and all these. I just wanted to make it as complicated as possible, so I added some more. The dispute, how this has been crystallized, and then the breach has been alleged. So then you see the loss and expense claim, the relevant matters. I've given the contract clauses 4.20.1, then clause 4.22. The thing I was discussing, the entitlements are under these clauses, and why is that? Why has that happened? You know, and how the claim was assessed, and how much payment has been received. And then, of course, this final thing, the quantification, and then description of the quantification of each head. And finally, the interest claim and the redress is sought. All these. Now, I will not, bother you to go through this at this point of time. I will send a copy to Julie, and you can ask a copy if you want. And I think that's all from me. And thank you very much once again for listening and joining us all throughout the year.
Okay, thank you very much, Mohammed. If you have a question for Mohammed that you're happy to ask now, please feel free to use the Q&A on chat facility, or as we said earlier, to contact him directly on mohammed.haque@fletcherday.co.uk. He'll happily answer those questions for you. If you'd like a copy of the document he's referenced, please email seminars@fletcherday.co.uk. As we said earlier, this is currently our last seminar for this year. Hopefully shortly we will be notifying you of the seminar schedule for next year, and I'm sure Mohammed will be right in the middle of that as usual. If anyone has any queries or any questions, please don't hesitate to contact us, seminars@fletcherday.co.uk. Otherwise, we strongly wish you a very, very Merry Christmas, as we will now be offline until at least January, and a Happy New Year. And thank you for joining us for this year and giving us your support. Mohammed, thank you as always for all of your useful information and the fantastic seminars you've been giving. And we look forward to seeing you all again next year. Take care, everybody.
Thank you. Bye-bye.
Thank you.